As we conclude this module, it is important to tie together the key themes we have explored: compliance, accountability, and professional conduct, and apply them to one of the most fundamental aspects of real estate practice: receiving compensation. While earning commissions and fees is the natural outcome of a successful real estate transaction, how a licensee receives compensation is strictly governed by Arizona law to ensure fairness, transparency, and compliance with the Arizona Department of Real Estate regulations. These requirements are primarily outlined under Arizona Revised Statutes, Section 322155, Arizona Revised Statutes, Section 32-2153, A10, and the Commissioner's Rules in AAC 4-28-1101E. Compensation in real estate refers to any form of payment, fee, commission, bonus, rebate, or other valuable consideration that a licensee receives in exchange for performing licensed activities, such as listing, selling, leasing, managing, or negotiating real property. The ADRE enforces strict guidelines about who may receive compensation, from whom it may be received, and how it must be paid. These rules protect the public from fraud, prevent unlicensed activity, and preserve the integrity of professional brokerage relationships. Under ARS Section 32-2155A, only a licensed real estate broker may receive compensation for performing acts that require a real estate license. Salespersons and associate brokers are not permitted to accept payment directly from clients or any other party. Instead, they must receive all compensation through their employing broker. This structure ensures accountability by placing the broker at the center of all financial transactions. It also enables the broker to maintain accurate records of payments and ensures compliance with trust account and disclosure requirements. For example, if a salesperson successfully closes a home sale and earns a commission, the title company must issue the commission check to the employing broker, not directly to the salesperson. The broker then disperses the appropriate portion to the salesperson according to their independent contractor agreement. If a salesperson accepts payment directly from the client, even with consent, that act violates ARS Section 32-2155B and may result in disciplinary action under ARS Section 32-2153A10 for receiving compensation unlawfully. It is equally important to note that a broker may only pay compensation to other licensed brokers or to salespersons affiliated with their brokerage. This means that a broker cannot pay referral fees, bonuses, or commissions to unlicensed individuals for activities that require a license. For example, a broker may not offer a finder's fee to a friend who referred a buyer unless that person is a licensed agent. The only exception, as outlined in ARS Section 32-2175A2, allows a broker to provide small token referral rewards to current tenants in a property management context, such as a one-time $100 rent credit, provided that the tenant does not engage in negotiating or showing property. Additionally, a broker may share compensation with another licensed broker in Arizona or another state, provided both hold valid and active licenses. For instance, an Arizona broker who refers a client to a California broker for relocation may legally receive a referral fee if both brokers comply with their respective state laws. The key is that the transaction must be fully disclosed, lawful, and involve only licensed parties. Licensees must also disclose all compensation and potential financial benefits they receive from a transaction. AACR 4-28-1101E requires that a licensee fully disclose in writing any compensation, commission, bonus, or rebate received from any source other than their client. This rule ensures that clients are aware of any potential conflicts of interest. For example, if a licensee receives a referral bonus from a home warranty company or lender, The licensee must disclose that arrangement in writing to their client before the transaction closes. Failure to make such disclosures may be deemed dishonest conduct, a violation of Arizona Revised Statutes, Section 322153A1. Compensation must also be earned through the performance of license activity. Under ARS Section 32-2151.02, licensees may not receive payment for services that fall outside the scope of their license, unless those services are separately contracted and disclosed. For example, a licensee may not collect additional consulting or marketing fees that are not part of a brokerage agreement without clear disclosure and consent. All compensation arrangements should be in writing and included in the employment or listing agreement to ensure clarity and enforceability. An important safeguard built into Arizona law is the prohibition against unlicensed activity and payment for such activity. ARS Section 32-2153A10 states that accepting compensation for performing acts that require a license without holding an active license is grounds for disciplinary action and potential criminal charges under Arizona Revised Statutes, Section 32-2165. This applies not only to unlicensed individuals, but also to licensed agents whose licenses are inactive, expired, or suspended. For instance, if an agent closes a transaction after their license has expired, they forfeit the right to collect a commission for that transaction, regardless of prior involvement. The ADRE also enforces the rule that compensation cannot be shared with or paid from trust account funds, unless properly authorized. Trust accounts, governed by ARS Section 32-2151.01 and R4-28-802, are reserved for client monies, such as earnest money deposits, rent payments, or security deposits. Brokers must disperse commissions and other earnings only from their operating accounts to ensure client funds remain protected and distinct from business income. Another layer of protection involves compensation disclosure during dual agency or limited representation. Under R4-28-1101F, if a licensee represents both buyer and seller, or if different licensees within the same brokerage represent each party, all parties must consent in writing to the arrangement and the disclosed compensation structure. This ensures that no party is misled about how the licensee's financial interests might affect their duties. Finally, compensation may be subject to restrictions during disciplinary actions or probation. The commissioner may, under ARS Section 32-2153A, impose conditions that limit how or when a licensee can receive compensation. For example, a broker under probation for trust account violations may be required to submit all commission disbursements for department review until compliance is verified. These restrictions are intended to rehabilitate the licensee and protect future clients. Review summary. In this section, you learn that a licensee may receive compensation for licensed real estate activities only through their employing broker, as required by ARS Section 32-2155. Brokers may pay or receive commissions only from other licensed brokers, and all compensation arrangements must be transparent and fully disclosed under AAC R4-28-1101E. Licensees are prohibited from accepting payment directly from clients, unlicensed individuals, or during periods when their license is inactive. Trust accounts may never be used for commission payments, and all compensation must reflect lawful, licensed activity. These rules ensure accountability, transparency, and protection of both clients and the public. Discussion: under what statute must all compensation for real estate activities be paid through the employing broker? Answer: ARS Section 32-2155. Why does the ADRE prohibit direct payment of commissions to salespersons? Answer: to ensure broker supervision, accurate record keeping, and legal accountability. What rule requires licensees to disclose compensation or benefits received from third parties? Answer: AACR 4-28-1101E. Can a broker pay a referral fee to an unlicensed individual? Answer: no, unless it qualifies as a minor promotional incentive under ARS Section 32217-5A2 and does not involve licensed activity. What happens if a licensee performs licensed activity after their license expires? Answer: they forfeit the right to any compensation and may face disciplinary action under ARS Section 32-2153A10. Closing remarks. Compensation is at the core of every real estate professional's livelihood, but it also carries significant legal and ethical responsibilities. Arizona's strict compensation laws ensure that all payments are properly supervised, transparent, and traceable through the broker of record. These safeguards protect consumers from financial harm and reinforce the professionalism of the real estate industry. Understanding and following these rules not only ensures compliance with ADRE regulations, but also builds trust with clients and strengthens a licensee's reputation as an ethical and reliable professional.